very good afternoon to one and all present here. I am Dr. Zara Dahodwala, student of MBA Hospital and Healthcare Management, and I welcome you all after your scrumptious lunch. Healthcare delivery has always been recognized as a comprehensive avenue, but recently there have been stringent norms to regulate the services in this field. In lieu of the changing perception about healthcare delivery and the emphasis on enhancing quality, it has become pertinent for hospital and healthcare managers to remain abreast of the new policy norms that regulate the delivery of healthcare. And today, to enlighten us on this topic of legal aspects of healthcare, we have with us Dr. Gopinath Shenoy. Sir has done his MD Obstetrics and Gynecology, LLB and LLM with first class, bagging numerous gold medals along the way. The University of Mumbai has also awarded him a PhD. He is a practicing obstetrician and gynecologist, as well as a medico-legal consultant who exclusively appears in consumer courts all over India only for doctors. Sir has his own hospital in Mumbai. Dr. Shenoy has numerous research papers to his credit. He also teaches the Indian Penal Code, the Consumer Protection Act, and criminology at various law colleges in Mumbai. He was a judge at Consumer Court in Mumbai. Sir has authored 2 books on medical negligence and was instrumental in bringing about a lot of constructive work in the consumer movement. I now welcome Dr. Shenoy to enlighten the delegates on the topic of legal aspects of healthcare.
Well, ladies and gentlemen, a very good afternoon. The lunch was beautiful. And whenever the lunch is beautiful, it makes my job very difficult. Because now what I've got to do is, I have to keep you all awake and then enlighten you. Because enlightenment always takes place when you are awake. So that is going to make my job difficult, but all the same, let's see how it works. First and foremost, of course, I've got to thank Dr. Rajiv Yavadekar and Vidya for having invited me over here. And I will be failing in my duty if I don't congratulate one and all who are here for having passed this particular examination. And now you are going to be a full-fledged medico-legal consultant. Something very nice. Welcome to the group. Ladies and gentlemen, Dr. Rajiv told me that in a matter of 1 hour, I'm supposed to enlighten you students with respect to medical law as far as possible. I said, yes, I will do it. Let's see how much we are able to do it, because I'm going to hold forth until the dignitaries come. And that's going to be maybe an hour or maybe a little more or a little less. Now, friends, you must be knowing medical law is not a statutory law. There is no statute with respect to law of medical negligence. Law of medical negligence is basically a judge-made law. By that I mean, it is the judges who tell us what is negligence and what is not negligence. So, if at all you're going to be, if you want to be very good at the law of medical negligence, what is required, but all the more, it has been passed by the Supreme Court, and that is why you've got to know what that judgment is. So let's see how we go about it and how time permits me to cover these 4 topics. First, the 2 English judgments. The first English judgment, which always plays a very important role, is the Bolam's judgment. I think this Bolam's law is one law that you people must have oft-repeatedly heard these words, but I bet very few of you all must be really knowing what is Bolam's law is. This Bolam's law is something which is the backbone of the law of medical negligence as far as the Indian courts are concerned. So I'm going to discuss that first. In this particular case, what happened was, there was a psychiatric case, a patient who was suffering from a psychiatric ailment. He went to his psychiatrist, and this happened in the UK, in England it happened. He went to his psychiatrist, and the psychiatrist said that this is an ideal case for electroconvulsive therapy, ECTs. At that point of time, there were 2 schools of thoughts when it came to giving the ECT. The first school believed in giving ECTs without muscle relaxants, and the second school believed in giving ECTs with muscle relaxant. You know what ECTs are, because most of you all are medicos, but for those people who are non-medicos, I'll tell you all. What is done is, you give a general anesthetic, pentothal sodium is given intravenously, and then you are given a muscle relaxant, as a result of which you are totally paralyzed, and then a small current is passed through your temples. Because of the muscle relaxant, the convulsions that you get, the fits that you get are very mild, and then you come out of the anesthesia and you are allowed to go home. That is how a ECT is given. Now, this Bolam was given an ECT by his psychiatrist, but he did not use muscle relaxants. When the muscle relaxants were not used, the convulsions were so violent in Bolam, he had fractures, including an acetabular fracture. This fracture was identified immediately after the ECT was given. Treatment was given, Bolam was well subsequently, but then what he did was, he sued the hospital and the psychiatrist. His contention was very simple. Just because you did not give me the muscle relaxant, I had such violent convulsions, as a result of which I sustained a fracture. Had you given me the muscle relaxant, this kind of violent fits would not have taken place. Maybe my bones would not have broken. I would have not been put to such a lot of inconvenience and trouble. The matter was heard by the courts, and this was one judgment which has really turned the tracks of medical law. The Bolam's judgment lays down the law on two aspects. The first aspect of the law that Bolam's judgment lays down is that Bolam's law says that when a particular problem can be managed in more than one ways, and if at all a doctor takes up the management in one particular method to the exclusion of the other, and suppose there is a problem, this problem per se does not mean that there is negligence on the part of the doctor. In Bolam's case, what had happened was, ECTs could be given with muscle relaxant, that was one school, and ECTs were to be given without muscle relaxant, that was the teachings of another school. Bolam's psychiatrist believed in giving ECTs without muscle relaxant. So the court said that there was nothing wrong in giving ECTs, provided it is being given by an established school, a method adopted by an established school. So that was the first law. The second law, which is even more important in Bolam's judgment, is the standard of care. This is very important. This you have to understand. What do you mean by the standard of care? Standard of care is the care that law expects from a doctor. When I'm treating a patient, law expects a certain standard that I have got to give the patient. And the law is very clear. The law says that the doctor need not give the best of the standards, and the law says the doctor need not give the worst of the standard of care. If at all the standards rendered by you are reasonable, that is perfectly all right. So what law expects from you is a reasonable standard, not the very best standard, nor the very worst of the standards. Why am I saying this? I'm saying this is because in litigation, in medical litigation, what happens is the patients and the patient's advocate puts textbooks on the records of the court and says that here is a textbook and this is all that is recommended by the textbooks, and the doctor has done nothing as recommended by the textbooks. Now, whenever such a statement is made in the courts, the answer to this statement is very easy. The answer is that following the textbooks verbatim is going to be treating the patient in the best possible manner. Does the law expect you to treat the patient in the best possible manner? Answer is no. The law says the treatment given by you need not be the best. Law also says that the treatment given by you should not be the worst. If at all the treatment rendered by you is somewhere in between, that is perfectly all right. So this is the Bolam's law. And based on Bolam's law, there are Indian courts have given various kinds of judgments. I'll give you a very simple case. There was a patient who came to her family physician, a female patient, a lady patient, who came to the family physician, and the family physician investigated the patient and identified that the patient was suffering from malaria. And the moment malaria was identified, the family physician prescribed a drug known as Rimodar, which is a sulfa combination. Now, this particular Rimodar is a tablet that is available. You have to swallow 2 tablets at a time. So this particular patient swallowed 2 tablets, the very first dose, and the sulfa component in this particular tablet reacted, as a result of which she had a full-blown Steven Johnson syndrome. It affected her eye, and finally she lost one eye. The matter went to the court. And here also, the contentions made by the complainant of the patient was that, why was Rimodar given? When there were so many other drugs available as antimalarials in the market, why did you choose Rimodar? Had you given me Camaquin or Nivaquin, maybe my eye would not have been lost today. I would have had my eye with me. The matter was argued in the court, and this particular Bolam's law was discussed by the courts. And the court said that, well, malaria can be treated by various methods. If at all the doctor has chosen one particular method to the exclusion of the other, and suppose there is some ill effects or some bad effects, that bad effect does not mean that the treatment given by the patient or the services, treatment given to the patient or the services rendered by the doctor was substandard, because as long as he has treated the patient by one of the established modes of treatment, that is what law expects him to do. So this is Boehm's law, and that is how the law has been settled by most of the Indian courts based on Boehm's law. The second English judgment that I feel that you all must know, now that you are going to practice tomorrow, maybe, or consult tomorrow, or help your colleagues who have medical legal problems, is the Rose case. Now, what do you mean by the Rose case? I'll tell you what happened in this case. A very interesting proposition you have to understand. It is known as Roe versus Ministry of Health, English judgment again. There was a patient who had a problem in the toe, and this particular patient was to be operated. So what happened was the anesthetist decided to give spinal anesthesia in this particular case. In those days in England, spinal ampules of xylocaine were kept in a bottle of phenol, and what the scrub nurse did, the theatre nurse did, was with a chisel forceps, she removed off one ampule and gave it to the anesthetist who was already washed up. The same thing happened over here. The anesthetist took the ampule, opened it, anesthetist gave spinal, which was beautiful. The spinal acted a little more because the patient just would not come out. And once they saw that the patient was not coming out of spinal, they identified that the patient had a permanent paraplegia of both his limbs. This was the case. So, spinal given, patient had permanent paraplegia, and the matter went to the court. Now, when the matter was pending in the court, the hospital conducted an internal inquiry, and they found out that in this particular ampule, that batch of ampules that were used, there were microscopic openings, as a result of which what had happened was phenol percolated into the xylocaine, and this was a phenol contaminated xylocaine that was used. Now you know how phenol works when it comes to the nervous system. Here what had happened was it acted on the nervous system, on the spinal cord, as a result of which there was a transaction of the spinal cord at that particular level, and this was a permanent transaction, and the patient just did not recover. The patient had permanent paraplegia of both his limbs. This was the matter. Now this particular judgment was argued, and one very famous English judge by the name of Lord Justice Denning was the one who decided this case. And you know what Lord Justice Denning said? Lord Justice Denning dismissed the case and did not pay a single pound as compensation to the person who is aggrieved. Just imagine a person subjected to wheelchair for the rest of his life and does not get anything as compensation, because Lord Justice Denning delivered this particular judgment and settled law on a very important thing which is known as foreseeability. Now this foreseeability, very few people know about what foreseeability is. Law says that if at all a particular problem is foreseeable by you, and if at all you are not able to identify it, and because of that there is a problem, then compensation becomes due and payable. But if at all a person suffers from a problem which is not foreseeable, not generally foreseeable, and some rare thing happens, if at all such unforeseeable problem comes up, then for such unforeseeable problems, compensation is not due and payable. Lord Justice Denning further went to say that in this particular case, it was never ever known that xylocaine ampules can have microscopic openings, because of which phenol can get contaminated. Phenol can contaminate xylocaine. It was not known. It was ever the first case ever reported. Lord Justice Denning also said that storing xylocaine in a bottle of phenol was a standard practice that was adopted all over the world. So whatever was done for the patient, there was no negligence. And this particular kind of a problem that came up in Rose's case was not foreseeable, and therefore there is no compensation due and payable. What a beautiful judgment. I think you all must read it if at all you have the time, but I have told you the essence of the judgment. Lord Justice Denning, in Rose's case, is known to settle down another very important law. And that very important law is known as the law of vicarious liability. If you read this Rose judgment, Lord Justice Denning says that if at all there is any problem that takes place under the roof of the hospital, it is not the consultant who is accountable to pay compensation, but it is going to be the hospital authorities who is going to pay compensation in this particular case. This is known as the law of vicarious liability, which most of you all must be knowing. Law of vicarious liability is something that is very much there in the law of torts, something which is very ghastly as far as the hospital administration is concerned, but something which most of the doctors very much welcome. Now, on this law of vicarious liability, I will tell you a little more before I go ahead. Now, if at all A creates a problem, suppose I am A and I create a problem, who has to pay compensation? A has to pay compensation. But there is a situation where the law says, if A creates a problem, A does not pay compensation, but it is going to be B who pays compensation. So, for a problem created by A doesn't pay compensation, but B pays compensation. Now, when does this happen? I'll give you an example. See, I've got a hospital. I tell my sister that this particular patient is for a herniorrhaphy, 80-year-old patient. I tell the sister, give this particular patient atropine half an hour prior to the surgery. And my staff nurse, instead of giving atropine, gives 1 ampule of adrenaline in a 80-year-old patient. The patient goes into arrhythmias, the patient arrests, the patient is never operated, and the patient dies. Here what has happened is, this particular negligent act of giving adrenaline instead of atropine has been done by whom? Has been caused by whom? By the staff nurse. Now, if at all this matter goes to the court, who pays compensation? By the law of vicarious liability, it is not the staff nurse who pays compensation, but it is going to be the hospital owner who has to pay compensation. That is what the law of vicarious liability is. Now, what is the relationship between two people for this particular law of vicarious liability to come into action? The relationship between the two people has to be either that of a master and a servant, that is an employer-employee relationship, or a principal-agent relationship. So, what is the difference between, now employer you know, principal means you know. Employee and agent, what is the difference between that? Employee gets all the benefits that any employee is getting, like the leave travel benefits, provident funds, gratuities. Whenever such a thing is given to a particular person, that particular person is known as an employee. But when it comes to an agent, the agent does not get all these benefits, To understand this concept better, I'll give you a very simple example. There is a hospital where there is a full-time staff as well as a part-time staff. Full-time staff are basically employees. There are the honorary staff, they are not employees, but they are agents who work for the hospital. So if at all an employee fires a case, or if an agent fires a case, it is not the employee or the agent who pays compensation. By the law of vicarious liability, it is going to be the institution that pays compensation. So you will ask me a question. If suppose a big hospital has got 100 employees and agents, 100 full-timers and part-timers put together, and if all the 100 employees and agents mess up with the patient, there's a huge amount of compensation to be paid, the hospital will go bankrupt paying compensation. That question always comes up in our mind. But does this happen? This does not happen because the law of vicarious liability is very clear. The law of vicarious liability says that it is going to be the hospital that pays compensation, but the hospital can always recover this compensation from an erring employee. That is why hospitals always conduct an internal inquiry. Remember, if at all there's a problem, an internal inquiry is conducted. And this internal inquiry is conducted basically to find out who is at fault, because if the hospital lands up paying compensation because of its vicarious accountability, this amount that has been paid by the hospital can be recovered from the erring employee or the erring agent, but this recovery has got to be done in installments. That is what the law of torts very clearly states. So, Lord Justice Jennings was one amongst the first ones to lay down this law about vicarious liability. Where does the law of vicarious liability does not become accountable, does not become applicable? The law says, and Lord Justice Jennings says in that particular judgment, Roe versus Ministry of Health, Lord Justice Jennings says that if at all the doctor has been brought into the picture by the patient, and if at all such a doctor messes up the case, then this doctor will pay the compensation and the institution will not be accountable to pay compensation in such a situation. I'll give you an example. There is a patient on a ventilator. You know, people are trying to wean him off. He's just not getting weaned. The family is a very big family, very big industrial family, and this particular problem took place.